Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. In a letter dated the 6th of January, Law Minister Kiren Rijiju has written to the Chief Justice of India making suggestions which, if they are accepted, could lead to a central government representative becoming part of the Supreme Court Collegium and a state government representative becoming part of each of the High Court Collegiums. So today we ask, would these suggestions undermine or damage the independence of the judiciary? And if the answer is yes, how should the judiciary respond? Those are the key issues I shall discuss today with one of the most highly regarded former judges of the Supreme Court and a former member of the Supreme Court Collegium, as well as several High Court Collegiums, Justice Madan Lokur. Justice Lokur, judging by newspaper reports, Law Minister Kiren Rijiju, in a letter dated the 6th of January, has made two suggestions to the Chief Justice of India regarding how judges are chosen. First, he wants a central government representative in the Supreme Court Collegium and a state government representative in each of the High Court Collegiums. As a former Supreme Court judge and a former member of the Collegium, how do you respond to this suggestion?
Thank you, Karan. You see, it's like this. I think we need to first of all understand what is the High Court Collegium and what is the Supreme Court Collegium. Now, the High Court Collegium consists of the Chief Justice of the High Court and the two senior most judges. They make a recommendation to the effect that, such and such a person, one or more, we think as the High Court Collegium should be appointed as a judge of the High Court. Now, the recommendation goes to the Chief Minister of the state, who has to give his comments on the recommendation. It goes to the governor of the state. He has to give his recommendation. Then it goes to the Government of India, to the Department of Justice in the Ministry of Law. The Government of India gives its recommendations or suggestions or objections, and then it goes to the Supreme Court. There it is considered by the Supreme Court Collegium, consisting of the Chief Justice of India and the two senior most judges of the Supreme Court. Now, what the Supreme Court Collegium does is it takes the opinion of judges of the Supreme Court who are conversant with the affairs of the High Court. Now, it could be a judge of the Supreme Court who has been a judge of that particular High Court, or who has been the Chief Justice of that particular High Court. There have been instances where a particular High Court, has sent 4 or 5 judges to the Supreme Court. In some capacity or the other, they have those judges have either been the Chief Justice from a different state, or they have been judges of that particular High Court. So the Supreme Court Collegium, has a very wide consultation within the Supreme Court. It has before it the views of the High Court. It has before it the views of the Chief Minister of the state, the views of the Governor of the state, the views of the Government of India, and the views of other judges of the Supreme Court, and then it takes a decision. So there are enough, inputs that are available with the High Court, with the Supreme Court. Now,
Can I just interrupt that point? Are you suggesting that because the Supreme Court has consulted so widely and the views of the Chief Minister, the Governor, and the Government of India are already available, there is no need for an additional government representative on the High Court Collegium or the Supreme Court Collegium?
Yes, that is one aspect. The second aspect is that what is that representative going to do? Okay. Now, the High Court judges are, at least the two senior most, are normally from the same High Court. Okay. They have been lawyers in that High Court. It takes almost about 20 years, in some cases more, some cases less, for these judges as lawyers to become judges of that High Court. So they have experience of about 20 years. All right. By the time they reach the Collegium of the High Court, they are about 10 years as judges. So they have 30 years experience of that High Court. And during that period of 30 years, they perhaps get to know almost all, or at least a majority of the lawyers in the High Court. They get to know almost all, if not a majority of all the district court judges. So they are in a position to know exactly whom to recommend, all right, through their experience of almost 30 years and exposure to lawyers for 20 years, both as members of the bar and as judges.
So you're saying that
Now,
in addition to a government
Yeah.
representative not being necessary, that government representative also won't know the lawyers of the state that are being considered anywhere near as well as members of the Collegium, whether at the High Court level or the Supreme Court level. So both a government representative would be unnecessary, but also inadequately informed and inadequately knowledgeable.
Yes, absolutely. Now, what is the role of that, government representative? Okay, he's going to search. How is he going to search? I mean, is he going to go from house to house and find out, whether this person is good or this person is not good? Versus the experience of the High Court judges who have, 30 years experience or 20 years experience or 10 years experience. What is that representative going to do? Right? And, we know as a matter of fact, I know as a matter of fact, that, when the Intelligence Bureau has been asked to conduct a search about the antecedents of a lawyer who has been recommended, it is on record. I mean, I'm not saying something which is not on the record. A person who's a teetotaler has been described as a boozer, right? Because his nickname was Boozer when he was in college. Now, what kind of a search is this?
I
There's
understand.
also another-
Can I interrupt and put this to you? In addition to a government representative, whether it's a central government representative or a state government representative, whether it's at the Supreme Court Collegium level or the High Court Collegium level, in addition to that person being unnecessary, and also in addition to that person being inadequately informed and inadequately knowledgeable, is the idea of a government representative also unacceptable?
Well, what is the role of that search person? What is his role? I mean, what is he searching for? Is he searching for political affiliations? Is he searching for cultural affiliations? What is he searching for? Is he searching for competence? Is he searching for merit? I mean, are you trying to say that the High Court judges don't know the competence of the person they're recommending or the merit of the person that they're recommending? And in any case, the Chief Justice of the High Court can make a recommendation that's there in the Memorandum of Procedure. Now, what better person can they be than the Chief Minister? So what is this representative going to do?
But then you're raising a very important question by implication. Clearly, this representative is not adequately informed and not adequately knowledgeable to be able to search for technical or legal qualification of the candidate being considered. It follows that what he will be searching for is what you call political affiliation or cultural affiliation, because that is about the only thing he'll be in a position to judge. Therefore, does that make a government representative at the Collegium unacceptable? Because he'll be searching for something that is not relevant and germane to choosing a candidate for judgeship.
Right, right, you're right. But then look at it from the point of view of the judiciary. Are you trying to say that the High Court judges are not, conducting a proper search? Is that what is the implication? Is that what is sought to be said by the Law Minister?
So there is also an implied slight to High Court and Supreme Court judges as well, because the suggestion is they're not doing an adequate job themselves. They need a government representative to help them.
You're right. That's one. The second thing is, when the recommendation goes to the Chief Minister, to the Governor, to the Government of India, they can say whatever they want to say,
So then let me ask you a third time. You've given me many good, cogent reasons why this government representative would be superfluous. He or she would be inadequately informed. It's an unnecessary person because the judges concerned and the other representatives whose opinions have been taken on board, like the Chief Minister, the Governor, have already given their opinion. Worse still, chances are this person will be looking for political and cultural affiliation rather than knowledge of the law. Therefore, I repeat my question. Is a government representative at the Collegium unacceptable?
It is. You see, in the sense that what is the role of this search person? Just to say that, we'll have a search, we'll have a representative. What is his role? Is he going to be there as a bystander? We don't even know what his role is. Okay. And unless you tell us, unless the government tells us what is his role, what's the point of saying, I'll set a representative? I'll set a representative for what? To have a cup of tea with the judges, or what? Okay. What is he going to do?
We've established, Justice Lokur, that a government representative either on the Supreme Court Collegium or on the High Court Collegium would be unacceptable. When I asked you that question for a third time, your answer was, it is unacceptable. Let's come to the second suggestion made by the Law Minister. He also wants, according to newspapers, a search and evaluation committee, which according to newspaper reports would comprise government representatives, former judges, and also academics. And this search and evaluation committee would suggest candidates to both collegiums, the High Court Collegiums and the Supreme Court Collegium, for appointment as judges. How do you evaluate and how do you respond to this second suggestion of a search and evaluation committee?
All right. Now, that representative who's supposed to be part of the Collegium, okay, is he a part of the search and evaluation committee? I don't know. Nobody knows. All right. It's not been told, at least I have not seen the letter that the Law Minister has sent. But nobody knows whether it's the same person or whether it's a different person. That's number one. Okay. If it's a different person, why have two different persons? If it's the same person, then why should he duplicate his efforts? Second, you have a person doing the evaluation, all right, or search and evaluation committee. What is the criteria for the evaluation? Again, is it, I don't know, again, political, cultural, religious? What is it? How do you evaluate? How do you evaluate merit as against High Court judges who know that person for the last 30, 20, 10 years? What is the evaluation criteria? We don't know what is the evaluation criteria.
Can I interrupt once again? It seems to me, and I'm asking you this as a question, that an academic on the search and evaluation committee or former judges on the search and evaluation committee would be equipped to judge merit and to judge whether the candidate being concerned knows enough law to be able to be a judge. But a government representative who's not a former judge, not an academic, would not even be able to do that. Therefore, if you do have a search and evaluation committee, Maybe judges are acceptable, maybe academics are acceptable, but a government representative would not be, because he or she would not be qualified to judge the legal ability of a candidate being considered.
Absolutely. Now, look at it from another perspective. The government of India is the biggest litigant in the country. Can a litigant say that, listen, I want to choose my judge? What are we talking about?
There would be a conflict of interest, and clearly the
On the face of it.
litigant would be choosing his own judge and jury, which is politically and legally unacceptable.
Yeah. So you say that, listen, I want to file a case and I want it to go before my judge or a person that I think should be appointed as a judge. So that, obviously the decision will be in my favor.
So once again, we're coming to the conclusion, and I'm talking specifically about a government representative on a search and evaluation committee. I'm not talking about the possibility of academics being there or former judges, but a government representative on that committee would be unacceptable. A, he or she wouldn't have the expertise to judge whether a candidate being considered is the right candidate. And B, there would be this conflict of interest because the government is the biggest litigant. So for both reasons, it would be unacceptable.
It would be unacceptable. Number one, it would be unnecessary because you're casting an aspersion on the High Court Collegium, and contribution would be nil, as I see it.
That is very, very clear. Let me then come to the so-called justification that the Law Minister has made available. In a tweet addressed to Delhi Chief Minister Arvind Kejriwal, the Law Minister claimed that his suggestions are in keeping with the Supreme Court judgment of 2015, which, as you know, struck down the National Judicial Appointments Commission. I'll quote the exact words used by the Law Minister in his tweet. The Supreme Court Constitution Bench had directed to restructure the Memorandum of Procedure of the Collegium system. Now, you were a judge on the Supreme Court in 2015 when this judgment was passed. Is what the court intended when it wanted a Memorandum of Procedure restructured what the Law Minister is claiming? Is this what they had in mind when they said restructured it?
Well, first of all, I don't know whether we used the word restructure, all right? But I'm assuming for the sake of argument that the word restructure was used. Now, after the judgment was delivered, it was pretty obvious that the Collegium system needs some changes. All right. So we said that, the Supreme Court said that invite suggestions from the public. Okay, how does one, modify the system, or how does one improve the system? 11,500 pages of suggestions were received. It was obviously impossible for the Supreme Court to, go through all of them. The government of India, the Attorney General for India, said that the drafting of the Memorandum of Procedure is the function of the government. All right. Even when the earlier Memorandum of Association, Memorandum of Procedure was prepared, it was prepared by the government. So, if a new Memorandum of Procedure has to be drafted, it has to be drafted by the government. And the government will take these 11,500 pages of suggestions into consideration. The Supreme Court had also requested 2 lawyers to go through these suggestions and to give a sort of a report. A report was given, but then people said, oh, we want some more time and all that. The Department of Justice, as far as I remember, they had opened up a website for these suggestions. So suggestions kept coming. What has happened to those suggestions? I don't know. The Department of Justice and the Law Minister are in a position to answer that question. Whether those 11,500 pages and more pages that came in subsequently were taken into consideration, I don't know. But what eventually happened was that the same Memorandum of Procedure that was drafted earlier in 1999, I think, was sent to the Supreme Court with some, very small minor changes. So to say that, well, it's restructuring and this, that, and the other, what has the government done since the judgment came for the last 7 years with regard to all these suggestions?
You're making a very important point, Justice Lokur, and I'll underline it for the audience. First, you're questioning whether the judgment actually used the word restructuring of the Memorandum of Procedure. This may be...
But Karan, I'm prepared to go along and, by way of, assuming that we did use the word restructure. Okay, so what?
But you're making a bigger point by implication. Even if the word restructured was used, but you're not certain it was used, you have doubts whether it was used at all, clearly restructuring the Memorandum of Procedure can't be done in such a way that you change the Collegium and the very nature of the Collegium. Because the nature of the Collegium was defined by the second and third judges' case judgments, right? It therefore can only be redefined by another judgment. It can't be altered and redefined by redefining the Memorandum of Procedure. That is the fundamental error in the justification being put forward by the Law Minister.
Yes, you're right. You're absolutely right. You see, the Memorandum of Procedure gives the procedure. It does not give the composition of the Collegium. The composition of the Collegium is given by the Supreme Court judgments, by 9 judges. So even if you assume that the word restructure was used, the restructure is with regard to the procedure as laid out in the Memorandum of Procedure, not in the Collegium.
Absolutely. So we now come to a very interesting and important conclusion. Not only are the 2 suggestions made by the Law Minister unacceptable, and just for the sake of the audience, I'll say the first suggestion is to include a government representative in both collegiums. The second suggestion is to have a government representative in a search and evaluation committee, which will be created. Both of those are unacceptable. But in addition, and this is perhaps more fundamental, the justification being put forward for these suggestions by the Law Minister is actually contradictory. You can restructure the Memorandum of Procedure, but you cannot restructure the Collegium because that is created by a judgment. You need another judgment to do that. The Memorandum of Procedure can't do it. So the justification itself is unacceptable also.
Yeah, it's flawed. The justification is flawed.
That's a wonderful encapsulation of the judgments, of the suggestions made by the Law Minister, as well as the justification for those suggestions. Let me move forward. The Law Minister's letter of the 6th, as you know, is only the most recent development. On several earlier occasions, Law Minister Rijiju has criticized the Collegium in public, calling it opaque, claiming it's non-transparent. After that, the Vice President, speaking in Parliament, went one step further and called the striking down of the National Judicial Appointments Commission a severe compromise of parliamentary sovereignty. Do you detect from these 2 individuals a concerted attack on the Supreme Court, and in particular on the Collegium, which is now the law of the land?
Well, first of all, I think we have to accept the fact that it is the Constitution of India that we, the people of India, have given to ourselves. All right? So therefore, the Constitution of India is supreme. You can't say that Parliament is supreme, or the executive is supreme, or the judiciary is supreme. It's the Constitution of India that is supreme. So any attack is actually against the Constitution. Now, why should the Constitution be attacked? I'm unable to understand that. And so you can say that, well, things need to change in the Supreme Court, things need to change in the legislature, things need to change in the executive. But you can't say that, the Constitution needs to be changed.
But you're saying something very important. You're saying that what I called or suggested was an attack on the Supreme Court, and in particular attack on the Collegium, is actually an attack on the Constitution. It's not just limited to the Supreme Court and Collegium, it's an attack on the Constitution.
It's a veiled attack on the Constitution. I mean, ultimately, if you're going to, diminish the role of the Supreme Court, you're going to diminish what the Constitution has laid down. All right.
So just
what
to
do you
sum
do?
up, you believe that the Vice President and the Law Minister have launched a veiled attack on the Constitution.
Well, I don't want to say anything about the Vice President, but I do think that there is a sort of a veiled attack on the Constitution through the medium of the judiciary. By attacking the judiciary, this is what is indirectly being done.
And this is being done by the Law Minister.
It's being done by the government.
Not just the Law Minister. You believe the government itself is behind what he's doing.
Well, yeah, that's the principle of cabinet responsibility, isn't it?
You made this point in a very cogent way in a recent essay you wrote for The Wire, which I believe was broadcast and published on the 14th. I'm going to quote what you said there. The recent utterances of Law Minister Kiren Rijiju, obviously on behalf of the government, make it quite clear that the government wants a committed judiciary. And then you added, the attempt is not overt as of now, but not as subtle as well. Slowly but surely, the government is moving ahead, and the results of the machinations will be apparent not now, but in a few years. For the benefit of those watching this interview who didn't read your essay in The Wire, can you briefly explain your fears?
You see, my fear is this. All of us, I mean, I don't think there can be any doubt about it. All of us expect an independent, impartial, honest judiciary, right? Now, if the government, which is the biggest litigant in the country, is going to start saying that, listen, we want our judges over there, you can't have an independent judiciary. You will have something called a committed judiciary. That's the expression that was used many years ago. So you will have a committed judiciary, a judiciary that is committed to it could be political ideology, it could be the philosophy, it could be whatever, of the government. Now, if you have a committed judiciary, then the judiciary has lost its independence. And if the judiciary loses its independence, well, one of the pillars of democracy is knocked out.
Do you suspect that one of the outcomes of a government representative in both collegiums, and perhaps also one of the outcomes of a government representative in the search and evaluation committee, assuming such a committee is set up, one of the outcomes of both will be the government's involvement in choosing judges? They will pick judges that affiliate with them culturally or politically and lead us towards a committed judiciary. That is one of the outcomes that you present. We will end up with a committed judiciary.
Yes. You see, political, cultural is just, one of the things. It could be religious. It could be anything, caste. It could be anything. One doesn't know. But the point is that we need an independent judiciary. And if this sort of a thing continues, it's not that from tomorrow onwards, the independence of the judiciary will go. It will take time.
But it will happen. But it will happen.
It will happen if this continues.
It will inexorably and inevitably happen if this continues.
Yeah.
Let me ask you one further question. Do you share the fear that because this government has undermined institutions like the Election Commission, the CBI, the Enforcement Directorate, and some people would even say the government has implemented manners and methods that have undermined the functioning of Parliament, do you therefore believe that permitting this government a role in the selection of judges would be particularly worrying and particularly dangerous because the government's own track record suggests that it is undermining institutions?
Well, I don't want to comment about other institutions like Parliament or Election Commission or CBI and all that. I don't want to comment about that. But the developments that have been taking place in the last couple of weeks, if not the last couple of months, and the track record of the government in dealing with the recommendations made by the Supreme Court clearly suggest, to me at least, that the government is looking for a committed judiciary. I can't understand why the case or why a recommendation made by the Supreme Court is kept pending for 2 years, 3 years. In the case of one person in Karnataka, he waited for about a year, and then he said, "Listen, I don't think I'm, I don't
You're
want to be a
talking
judge."
about Aditya Sinha.
I'm talking about Aditya Sondhi.
Aditya Sodhi, my apologies.
Yeah. So he said, I don't want to become a judge. I want to withdraw my consent. Now, when you're talking about evaluation, search and evaluation, what was the evaluation that was done to keep his file pending for 1 year? You have the case of one lawyer from Bombay, Mumbai. His case is pending for 2 years or 2.5 years. What is the evaluation done? You have well-known Saurabh Kirpal pending for I don't know how long. You have so many cases. You have cases of the Supreme Court judges. Justice Dipankar Datta's case was pending for 75 days. What was the evaluation done?
And he was a sitting Chief Justice who presumably had already been evaluated.
Right. Justice K.M. Joseph, he was a sitting Chief Justice. What was the evaluation done? And his case was kept pending for months together.
So the point you're making, Justice Lokur, as you put it, the developments of the last few months, as well as this government's track record in handling and responding to recommendations made by the Supreme Court Collegium, clearly suggest, both of them clearly suggest, that this government is looking for a committed judiciary. And therefore, it follows that involving representatives of this government in the selection of judges would be particularly dangerous and particularly worrisome. It would be anyway worrisome in your eyes for any government to be involved. But in the case of this government, given its behavior over the last few months and given its track record of dealing with the Supreme Court, it would be particularly dangerous in this government's specific case.
Well, any government doing this, is dangerous. All right. This government has shown from its track record right now, a wide track record. Yeah. Even right now, Supreme Court has made recommendations for the appointment of 5 judges to the Supreme Court, 5 or 4 judges to the Supreme Court in December. All right. Evaluation is going on for the last 1 month. And then there are some other recommendations which are processed in 2 days. What is it? What is it? What is the explanation for this?
Absolutely, which is why involving this government would be particularly dangerous. But anyway, involving any government is bad, but this government is particularly dangerous. Before I take a break, let me put one more question to you. In your Wire article, you write, and I'm quoting, independence of the judiciary is a basic feature of our Republican Constitution and democracy. Do you believe that the Collegium system as it exists today is central and critical to maintaining the judiciary's independence? And if that Collegium system is tampered with, particularly to include government representatives, then it would end up undermining the independence of the judiciary.
Yes, it would. It would, yes. You can't tamper with the Collegium system for 2 reasons. One, of course, is the independence of the judiciary. Second, 9-judge bench of the Supreme Court has said that we need a Collegium system. And incidentally, earlier the power of, looking into all these things was with the Chief Justice of India. But the Supreme Court said that instead of conferring this power on one individual, let's have a collegium, so that there will be a discussion. So you can't, just say that, one person will, be the sole authority. There has to be some check. There has to be some discussions. And that can be done with more than one person.
So let me sum up the point you're making. The Collegium system as it exists today is central to and critical to the independence of the judiciary. And if you tamper with the Collegium system, particularly to include government representatives, whether at the Supreme Court level or the High Court level, then that tampering will lead to damage to the independence of the judiciary. So ultimately, your criticism and opposition to the Law Minister's suggestions is that they will damage the independence of the judiciary.
Yes. Yeah, you put it perfectly correct.
I need to take a very quick break at that point, but when I come back, I want to touch on the critical subject. How should the judiciary respond to these suggestions? That is something that you have also written about in your article and essay for The Wire, but at that time, we were not aware of the specific suggestions made by the law minister. Now that his suggestions are out in the public domain, I want to pick up and elaborate on what you think the judiciary should do. A quick break and we'll be back. Welcome back to a special interview for The Wire with one of the most renowned former judges of the Supreme Court, Justice Madan Lokur. We're discussing the two suggestions widely reported in the newspapers made by Law Minister Kiren Rijiju to the Chief Justice of India, A, about involving government representatives in both the Supreme Court Collegium and the High Court Collegium, and the second being a suggestion that there should be a search and evaluation committee to choose candidates for judgeship with government representatives on that as well. And Justice Lokur has told us that in his eyes, both of those suggestions are unacceptable. We come now to how the judiciary should respond. Remember, Justice Lokur has also said in part one that tampering with the collegium will end up damaging the independence of India's judiciary. And the independence of India's judiciary, he says, is a basic feature of our constitution. That's a third reason why the suggestions are unacceptable. Justice Lokur, in an article you wrote for The Wire, published on the 14th, just days before the law minister's suggestions were made public, this is what you wrote about the general attitude of the government to the Supreme Court and your belief that this government was looking to create a committed judiciary. You said, and I'm quoting you, we have to stop the juggernaut and stop it now. The full complement of judges of the Supreme Court must sit and introspect and decide how to preserve and protect the independence of the last bastion from a government that seems bent upon destroying its independence. And then you added, please do everything possible. What does everything possible mean?
Well, by everything possible, I don't mean go to war or something. What I mean is that the Supreme Court judges, most of them, if not all of them, except for those who've been appointed from the bar, most of them have been chief justices of at least one high court, right? I think if there is an exchange of views of what are the problems that you've been facing in the past, right? What are you anticipating at the moment? Get their views, get their experiences. After all, they've been chief justices and they're now in the Supreme Court, so they're obviously competent and persons of merit. So get their views, right? Get the views of senior lawyers. You have, very talented, highly respected lawyers, somebody like Mr. Fali Nariman. Get his views, the former Attorney General for India, Mr. K.K. Venugopal. Get his views, have a wide consultation, introspect, because you know how the collegium system works. There are some gaps in every selection process. There are gaps. The idea is to try and minimize, those errors or to reduce those gaps. You can even request a discussion with the law minister. I remember on an earlier occasion when Mr. Ravi Shankar Prasad was the law minister. I don't remember what happened, but we requested him, to come to the chamber of the Chief Justice for a brief discussion, and he came. It's not as if he was demeaning himself or any such thing. He came because he knew that, well, it's important to have a discussion. So I don't see why
that the full complement of the Supreme Court judges, whatever it is at the moment, 29, 30, 31, the full complement should get together, introspect and discuss, get opinions from leading lawyers, get opinions from other established entities whose opinion would be valued, and then together decide how to respond to the law minister's suggestions.
Well, I don't know whether they have responded to the law minister's suggestions, because the letter, if you remember, is of 6th of January, right? So about 2 weeks have gone by. So I don't know whether there already has been a response, but assuming there is no response, sit down, think about it, call the law minister, request him to, have a cup of tea and to explain what he wants to say.
In other words, do it collectively, do it carefully, do
Yeah.
it after introspection.
Yeah. And it's not as if, the law minister should be requested to come and meet all the judges of the Supreme Court. He can meet the Chief Justice and the 2 senior-most judges, or the Chief Justice and the 4 senior-most judges in the Collegium.
But the important thing is that the collective mind of the Supreme Court should be put into handling this matter.
Right, because they have the experience as Chief Justices of High Courts.
Now, before we end, let's look at the Collegium as it exists for a moment. The truth is that it's not just the Law Minister who's been critical of its functioning. Criticism of the Collegium's functioning, not its existence, but of its functioning, has also been voiced by judges like Justice Chelameshwar, Justice Kurian, Justice Rumapal. They've accused the Collegium of being opaque, of lacking transparency, accountability, and objectivity, of even operating on a you scratch my back, I'll scratch your back basis. Are there changes that we need in the way the Collegium functions while still protecting and preserving its existence?
Yes. The you scratch my back, I scratch my back. When I was in the Collegium, I never had that experience. Okay. So I can't say whether that is correct or incorrect. It may have happened. It may not have happened. I don't know. It did not happen when I was in the Collegium. But yes, the functioning of the Collegium does require a change. I don't think anybody has said no, that the Collegium system is perfect. I don't think anybody has ever said that, right? It does require some change in the sense that when you're dealing with, the question of appointment, and by the way, let me tell you, there were changes when I was in the Collegium, which were brought about by, after discussion with the Chief Justice of India, there were changes. So it's not as if, what happened in 2005 continues. There were changes and there can still be more changes. Okay, for example, a better defined criteria. Let me give you one example. One of the requirements is of income that there's there in the Memorandum of Procedure. It's not a secret or anything. That a person should have a particular level of income. All right. Now, a lawyer in Delhi will meet that income criteria very easily. But a lawyer in Mizoram or a lawyer in Meghalaya may not meet that income criteria. Okay. So you have to have that balance made out. Now, this is one thing that can be looked at. Okay. Important judgments. You get a lot of important cases in Delhi, but you do not get so many important cases in Meghalaya. Okay, so how do you evaluate? These are things which need to be thought about, and which is why introspection is necessary.
Can I suggest some other changes that people have canvassed in articles and papers? Sometimes it said maybe more judges than just 5 should be consulted. Increase the depth of consultation both within high courts and Supreme Courts, and perhaps even quietly by approaching lawyers and academics. Would that be acceptable as a change?
Well, so far as the Supreme Court Collegium is concerned, like I had mentioned earlier, they already, consult judges from amongst their colleagues who are associated with the High Court. So, like I said, there have been instances where 4 or 5 non-collegium judges have been consulted.
What about consulting eminent lawyers like Fali Nariman, Mukul Rohotgi, Kapil
they are consulted.
Abhishek Singhvi?
Yeah, they have been consulted. I know as a matter of fact that it's a fact because I was the person. When I was Chief Justice of Guwahati High Court or Chief Justice of Andhra Pradesh High Court, I did consult senior lawyers that, this is a person who is being considered. What is your view?
So that level of consultation is already happening.
It's happening. Well, at least it happened with me. I don't know whether others do it or not.
When you were a member of the Supreme Court Collegium, was it happening? Were you reaching out to eminent lawyers while considering candidates for
Well,
judges?
I was reaching out to colleagues. You see, because that evaluation process has already been done by the time the file comes to the Supreme Court.
Another
You know?
concern is that quite often
Yeah.
the Collegium ends up nominating relatives or chamber juniors. And often this is considered nepotistic. How does one ensure that doesn't happen?
Well, there is this, like I said, there is a very rigorous evaluation procedure. All right. Somebody should raise an objection and say that, listen, this guy, I think, is not good enough, but he is being recommended by the High Court Collegium because he's a relative of somebody or the other.
But you're putting your finger on the problem. When you say somebody should raise an objection, clearly that somebody is not raising an objection. How do you ensure that the judges who are part of the Collegium, whether at the Supreme Court or High Court level, raise those objections and are not put off doing so because the candidate is a fellow judge's brother or nephew or son or a chamber junior or someone you know well?
Why can't the Chief Minister raise that objection?
But why can't the judges raise it as well?
They can, of course they can. And they do. They do. Why not? Why can't the Chief Minister do it? Why can't the Law Minister do it? Why can't the Governor do it? I mean, what's the point of saying that judges are like this? But you have the opportunity to raise.
But the point I'm making, Justice Lokur, is clearly not enough people have raised objections because it's well known that relatives of judges who are in the Collegium have been made judges. It's well known that chamber juniors have been appointed to judgeships. So clearly, it should be objected to, but it's not being objected to. How do we therefore ensure hereafter it is objected to?
Right. So therefore, when you have a selection criteria, let me give you one example. A member of the Supreme Court Collegium, a person who, according to the Memorandum of Procedure, was not eligible to be considered for appointment of a High Court judge, was recommended but he happened to be the nephew of a member of the Collegium. Now, if the judges don't exercise self-restraint, what can you do?
What is the answer to that question? Because that is the problem. One reason why people say the Collegium should comprise more than just judges is because sometimes judges don't exercise the sort of restraint that's required.
That's where transparency comes in. That's where transparency comes in. Where it is known in the corridors of the bar of every High Court who are the persons who have been recommended by the High Court, by the High Court Collegium, right? But officially, it's not known.
You're saying it should be officially made known who are the people being considered?
Yeah. No, who are the people who've been recommended?
I.e. being considered?
Yeah. Considered on the basis of some criteria. So some criteria has to be laid down.
So you're saying two things. A, we need clear-cut criteria on the basis of which people will be considered. And secondly, the names of those who are being considered should also be known.
Well, considered in the sense that, I'm considering 10 people, right? But I'm recommending 5.
But we should know both who are the 10 you're considering, also who are the 5 you recommended, and also the criteria on which they were recommended.
Well, I'm not sure, whether those 10 should be known to everybody, because it may damage the reputation of those 5 that you have been considered but rejected, right? I'm not sure about that. But those 5 who have been recommended, their names should officially be known. I mean, they're known unofficially to everybody, but officially they're not known. And the criteria is known, and that these persons have been selected, and these persons.
And this would amount to sufficient transparency?
To an extent, yes. But I suppose there could be other ways. I mean, I'm just telling you off the cuff. But
and the other important thing you're saying is that judges must be aware that it is not acceptable, unless the candidate is outstanding, that relatives of fellow judges should be promoted to judgeships or chamber juniors. That is something they should be very conscious and aware of, because it smacks of nepotism each time it happens.
Yeah. Because then, they should be aware of it, because then people will raise fingers at the impartiality of the Collegium, which is not
And
good.
if these steps that we've discussed are put in place, do you think the concern about the Collegium expressed by, say, the Law Minister or the Vice President will disappear? Do you think this would reassure them? And therefore, what they are suggesting, which we now know you think is unacceptable, those suggestions would stop?
Yeah, well, these are some suggestions. There are several other suggestions that can be made. I'm not saying that whatever we have discussed is the, final answer. No, it's not. There are so many suggestions. Like I said, 11,500 pages of suggestions were given. Some of them may have been good.
So you're saying two very important things. While saying clearly and categorically that the Law Minister's two suggestions are unacceptable, they would undermine and damage the independence of the judiciary, you're also saying that judges themselves need to think about how to improve the functioning of the Collegium to make it transparent. And one way of doing that is to establish criteria. The other way is to make it officially known who's been recommended from the High Court level to the Supreme Court level, etc. And they need to also think about other changes so that the functioning improves and judges are not accused of nepotism in the selection they make.
Absolutely.
One last question.
Yeah.
Does the Supreme Court do enough to defend and enforce the Collegium's decisions? And this is an important question because we're coming to the conclusion that the existence of the Collegium is critical to the independence of the judiciary, and that independence is critical to our Constitution. So does the Supreme Court do enough to enforce and defend your decisions? Because in November, it was revealed by, I think, Justice Sanjay Kaul in court that 11 names had been reiterated, i.e., sent to the government twice, and the government had not acted. All the court said at the time, and I'm quoting, was such practice of withholding approval is unacceptable. But this failure to act on reiterated names is actually a breach of the law, and it is probably contempt of court. So shouldn't the Supreme Court have acted more toughly rather than this gentle wrapping off the knuckles?
Yeah, you see, the problem is that if the government is obdurate, right, and says that, no, we will not do it, what can the court do? They can't, catch the law minister by his collar and say that, listen, you better do it. They can't do it.
Why can't you hold him up for contempt of court?
Maybe you can, yes, but why not? You have, like I said, we've discussed this, you have cases pending for years together. What has the Supreme Court done? They've said it's okay if it's pending for years together. But then tell them why is it pending? Why don't you tell us?
But the Supreme Court's not doing that. In fact, I'm going to quote what you wrote. I'm going to quote what you wrote in The Wire. One mistake of the recent past is that the Supreme Court did not stand up to the government when it should have in matters of appointment of judges. And you added, why is it taking months and years to process the recommendations of the Supreme Court Collegium? And what is the Supreme Court doing about it except letting the government get away with it? Now,
Correct.
Getting away with it must stop.
Yes, it must stop. It must stop. Certainly. You see, otherwise, today, right now, we are facing this problem. Recommendations have been made for appointment of judges to the Supreme Court, and they are pending with the government for more than a month.
So therefore, surely it follows that when names are reiterated, not the first time they're recommended, but when they're reiterated, and the Supreme Court judgment requires that on reiteration, the government accept. But when the government still fails to accept, surely the law minister should be hauled up for contempt of court. You do it once, embarrass him, he'll never stop this again.
Well, it's not only one reiteration. There are cases where the reiteration has been made for a second time. And I think there are one or two cases where the reiteration has been made for the third time.
And still the government hasn't acted, and still the Supreme Court has done nothing. So the situation gets worse and worse and worse, and the Supreme Court isn't acting. Which is why I come back to my question. Why is the Supreme Court not holding up the law minister for contempt of court?
Yeah, well, you see, normally it would not be the law minister, but it would be the secretary in the Department of Justice. Because
Whoever,
he's
but
the
why not hold him up?
Yeah, sure, why not?
I mean, you need to make an object lesson of people who are acting in contempt of court. You need to make
Yes.
an object lesson of people who are repeatedly, not once, but repeatedly in breach of the law. And yet the Supreme
Yes.
Court is very politely doing nothing.
Yeah, yeah. Yeah, they should, I think, send a notice to the secretary in the Department of Justice and ask him what's going on.
So the final conclusion we're coming to is this. Just as you think the law minister's suggestions are unacceptable, just as you think that if they were to be acted upon, they would undermine the independence of the judiciary, which is central to our constitution, so in the same way, you also believe that the failure of the Supreme Court to stand up and enforce its own collegium's decisions is unacceptable, particularly when names are being reiterated not once, but twice and three times, and the government is still not acting. This failure to act by the Supreme Court is also unacceptable.
Yes, 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 absolutely.
Justice Lokur, I thank you for this interview, and in particular, I thank you for explaining the details of how the Collegium at both levels, High Court and Supreme Court, work, and helping us understand, therefore, why the law minister's two suggestions are unacceptable, but also boldly and bluntly agreeing that the Supreme Court's failure to enforce its own Collegium's decisions and its repeated failure thereof is also unacceptable. I thank you for this interview. Thank you very much.
Thank you. Thank you. Yeah, thank you, Kiren.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.